I am proud to say I am represented by very able counsel.
Will counsel please identify themselves for the record? Thomas G. Newsom.
William B. March.
Daniel G. March.
Robert Henning.
Miss Rosenberg, are you a member of the legal profession of Los Angeles?
I'm proud to be a member of a profession which has been in the forefront of the struggle for civil rights.
Are you a member of the Communist Party?
I'd like to answer that question in this way. I don't think you're at all interested in the Communist Party. I agree with what was said, and I quote from
Will you answer the question?
I will answer, and I will answer it in my way. I do not even concede your right to ask the question. I will certainly not relinquish my right to answer the question in my way. I ask leave to answer that question in my way.
Now you can ask a very simple question.
That question is not a simple question. That is the question that you ask in order to frighten people. You think if you throw that word around, people will genuflect before you and hide. With some, unfortunately, it has had that effect. I am not frightened by a word.
Will you answer the question?
I will answer it, and I am answering it. And I want to tell you that you are not after communists at all. You are after conformity.
Will you answer the question?
You want everyone to, as you will, so that you can lead them on the way to war.
I direct the witness to answer the question. Mr. Tavner has asked you whether or not you are a member of the Communist Party. Are you or are you not?
I will decline to answer that question, and I will decline to do so on the following grounds. In the first place, I agree with Bernard DeVoto, who says it's not anyone's damn business what I think, with whom I associate, and with whom I have cocktails. And I concur in that view. I think, I have not finished, I wish to say all the grounds. I think that that very question makes an inroad on my right to think, and not only on my right to think and to speak, but on the rights of others to think and speak. Because, as Walter Lippmann said, it is necessary to have an opposition, and he calls it an indispensable opposition. And this is what he says.
Does he call the Communist Party an indispensable opposition?
I think from what he says, you may gather any conclusion that you like, but I want to read what he has had to say about
There's a portion of the constitutional grounds upon which you're refusing to answer.
It is indeed. It is the First Amendment. And I am pleading the First Amendment in two fashions. One, my right and the right of everyone to speak, and my right and the right of everyone else to hear. And we take, says Walter Lippmann, a naively self-righteous view when we argue as if the right of our opponents to speak were something we protect because we are magnanimous, noble, and unselfish. The compelling reason why, he says, and I agree, if liberty of opinion did not exist, we should have to invent it, and it must be restored wherever it is suppressed, as here. And it is that we must hear what the opposition has to say, because freedom of discussion improves our opinions. So the liberties of other men are our own vital necessity. There is a point where the freedom of others is no longer a question of their rights, but of our need. And this is the creative principle of freedom of speech. Not that it is a system of tolerating error, but it is a system for finding the truth. And I think that this democracy is an experiment in truth. And so you must have the opinion of all. There must be this interchange and interaction of opinions before the truth can emerge. Otherwise, you have deadly conformity, so that men go around with eyes shut, with ears shut, with lips silent. And what is that? That means yielding to this committee and its kind the determination of our destiny, the destiny of the people. I will not be part of that, and I will not relinquish my hurt. I stand on that ground.
Allow me to say that your freedom to speak has certainly not been limited today.
But I have had to struggle for it. I have thrice been interrupted.
If it goes on you will probably be thrice interrupted more.
Are you saying, Mr. Jackson, that I cannot stake the ground on which I rely?
I am saying
well,
that you
say it then so that I can know.
You certainly should be able to phrase your reasons in something less than...
Don't tell me how to answer. I don't even like your questions. I certainly would adopt your answers. These answers will be mine.
Well, I might say that I don't like your statements that you like.
Well, that's a delight to me.
That's the freedom to disagree if you speak.
Remember that and see that you execute it throughout, not just here where we struggle for it. The second ground for my refusal to answer that question is because I believe, despite the pious declarations of some members of this committee and of council, it is an invasion in the area of the lawyer-client relationship. And I will tell you why I think this is so. Of course, I think no one should be subjected to the coercion of this committee. And I think it is particularly vicious when lawyers are. When lawyers are attacked, it is an attack on the people. Because it is in the tradition of this country that lawyers have been the spokesmen of the people. As Justice Douglas says, they are to be more than just an echo of people's views. They are to be in the advance guard. And when you strike at the advance guard, particularly the dissident and the nonconformist advance guard, you strike at the right of the people to speak out. For if you subpoena me, let us not be naive. Those who look to lawyers will be silent. And that is precisely your point. And it does not matter whether I or my brave colleagues here are not silent. People, unfortunately, too frequently are intimidated by the subpoena and the blacklist. And I say it is naive to think that my clients will not be affected by my subpoena.
Have you ever appeared on behalf of anybody subpoenaed before this committee?
I have not, but I would like to finish the rationale, my approach on why I think that lawyers particularly should not be summoned before this committee.
But it seems strange to me that those lawyers who are advancing this argument
I have not finished my
as far as
argument.
I'm concerned,
That is not
in matters of this sort.
You mistake my point. If you will allow me to finish, it is not alone representation here that controls. It is representation everywhere where counsel is needed, whether in the courts or in administrative bodies. How can a client feel secure in going to an attorney who has been subpoenaed? Doesn't he feel that somehow his confidential communications may be encroached upon? It doesn't even matter whether you will or not. So if I permitted it, I have no doubt you would. I am now speaking of the client's view when his attorney is summoned. He may well feel that the confidential relationship, even if only to the extent of naming him, will be an encroachment and an invasion of that relationship.
Don't you think the easiest way to eliminate that possibility would be to frankly and openly and honestly answer these questions?
I am going to answer these questions frankly and openly and honestly,
You just declined to answer.
as I understand a frank and open disclosure. And I will say something to you, sir.
You just declined.
There will come a time in this country when there is no climate of fear and coercion and hysteria, and people will, of their own free will, declare with pride and with honor, as the Puritans said they would be glad to declare their faith, but not under compulsion, not because there will be a subpoena over my head or a blacklist, not if the result will be loyalty oath. This is precisely what has happened in civilization since you've asked that question. The Puritans were proud of their faith. The Jews were proud, too. And yet, when they were faced with Torquemada and with Hitler, what would you have expected, sir? That they should rise up and say they are Jews? If the cost of that would be their head? Today, the cost of declaring one's faith, which I say you have no right to ask me about, is a blacklist and a subpoena and a loyalty oath and book burning. This has been the result of the force and violence of this committee.
Where has any
Practice on it. Let me give you a precise illustration. I'll come back to it.
I'll withdraw this question.
I don't want you to withdraw. In Tulsa, Oklahoma, books were burned. And do you know what the American Library Association said?
No, this is an answer to the question asked by counsel. If so many witches left their brooms and full hats around, we wouldn't have so much work to do.
If you didn't interrupt me, I'd give my answer. So if you'll be good enough to sit back there, I'll give you
I
my
wish you would
answer.
get on to giving the answer.
If you stop interrupting me, my name is Mrs. Rosenberg. I'm the mother of 4
I
children.
congratulate you.
Please
Will you
answer.
please answer the question that is
I will
directed by
answer.
counsel?
That he should cease interrupting. There have been book burning.
I didn't ask you about that.
You did. You asked me where, and I said,
Very quickly.
why don't you talk to the booking, and I won't have to answer any questions.
Mr. Chairman, am I to understand now that all questions except the question by counsel are withdrawn? All right, you may proceed then to answer counsel's question.
Mr. Chairman,